Now, yesterday, a Dane County Circuit judge ruled that the law violates both the state and U.S. Constitution. The ruling strikes down provisions of the law. The law basically took away most collective bargaining rights for most public workers. Democrats, like State Senator Chris Larson, are celebrating the decision, but Republicans say the fight is far from over.
I think it's a big victory for not just for the workers, but also for all of Wisconsin, people who like free speech and due process and are interested in making sure that the Constitution is upheld.
Act 10 is a way to uphold the taxpayers' best interest and to have local governments and municipalities and the state legislature have the power to decide what is financially feasible for the state and for local municipalities.
It's not clear if the ruling means the law is immediately suspended. Either way, Walker's administration says it will appeal the decision. Now, the ruling came as a surprise to many. Now, lawyers are trying to explain what it means for workers. Fox 6's Brandon Cruz has that part of the story.
Friday night at the state capitol, teachers celebrate a Dane County judge's ruling striking down Act 10. A day later, we're learning more about the ruling's immediate impact.
Unions that are certified, even though they don't have contracts, they are now, under the terms of this ruling, back where they were before the law was passed.
Judge Juan Colas's decision says laws can't restrain certain rights. Quote, when the government elects to permit collective bargaining, it may not make the surrender or restriction of a constitutional right a condition of that privilege.
We cannot, through a legislative process, which is what Governor Walker and the legislature attempted to do, is go back on our word to our people.
The governor blamed partisan politics for the ruling, issuing this statement, quote, sadly, a liberal activist judge in Dane County wants to go backwards and take away the lawmaking responsibilities of the legislature and the governor. We are confident that the state will ultimately prevail in the appeal. But prosecutors in the case disagree.
If the judge was politically biased, why did he rule in favor of the state in part of this case?
Now, for municipal unions, it means going back to the conditions before Act 10 went into effect.
The contract exists as it was in January 2011. So the district has some major modifications to make.
The state's Attorney General J.B. Van Hollen says that he will appeal the ruling. He also says that he will be seeking a stay of Friday's decision pending appeal in order to allow the law to continue in effect. But John Matthews of Madison Teachers Incorporated says that he's confident that the law is and will remain unconstitutional. Madison Teachers Incorporated lawyers don't expect a final decision on any appeals for at least 6 months. Live in the newsroom, Brandon Cruz, Fox 6 News.
All right, a lot of people will be watching this closely. Brandon, thank you. In Chicago, it looks like kids could be